All right, good afternoon, everybody. Thank you for joining us. We have Commissioner Jonathan Lack presenting for us today on parenting plans. And I did hit record, so you should receive an alert that we're going to be recording this presentation for future use and for those unable to join us today. Commissioner Lack, I'm just going to make sure here that you can share your screen for your presentation. I think you should be good now. All right, and thank you, Commissioner Lack, for your time.
Okay, so I'm trying to figure out one thing here, and I'll be with everybody.
No problem. And as a reminder to everybody, please make sure that you are muted. And then Commissioner Lack, if people have questions during the presentation, do you want them to wait to the end, put it in the chat, interrupt? What's your preference?
My preference is that if you can interrupt, that's great. Crowd that we can do that. If you're uncomfortable interrupting me for some strange reason, you can also put it in the chat box. I've got the chat box open so I can kind of look at the various screens and try and keep up with those.
Great, thank you. All right, I will go ahead and mute and turn off my screen as well, but I'm here if you need me.
Thank you. So thank you, Kaylee, for the invitation and for putting all this together. I also just kind of want to start with a thank you to the courthouse facilitators. I am, of course, Jonathon Lack, King County Superior Court Commissioner. I use he, him pronouns. I've been here just over 4 years, but before that I was on the bench in Thurston County for 6 years. And before that I was on the bench in Anchorage, Alaska as a commissioner. The title there is called Master for about 6 years, 5.5 years. And when I came to Washington State to be a commissioner, I had never been in a courtroom prior to me being sworn in. And so it is the facilitators who taught me Washington law, taught me the myriad of forms and how to do all this. I would have been lost without the facilitators in Thurston County. And so I probably more than anyone else understands how important you are and how you make our lives easier. As Kaylee indicated, if you have questions, just let me know. Please interrupt. If you don't want to interrupt for some reason, you can also put them in the chat box and I'll try and cover them that way. But just so you know, as again, I am a commissioner with the King County Superior Court. I've been doing this for about almost completed my 16th year on the bench. I also teach at Tacoma Community College. I teach family law as well as a couple other classes in the undergraduate paralegal program. And then this last quarter, I taught family law at the University of Washington, and it looks like I'll continue to do so into the future. So I enjoy teaching. So if there's something that you see that's wrong, please let me know as well, because I do want to first admit that I make mistakes, and second, admit that you all probably know most of this work better than I do. Plans, and this is kind of an introduction to parenting plans. And if you haven't picked it up, I'm a Star Wars fan, so Star Wars will be throughout all of this. The subtitle for today's presentation is The Rise of the Facilitators. All right, so what are our learning objectives for today? And ideally, I want to help the facilitators as you're reviewing parenting plans to assess or address the appropriate parenting concerns and figure out how to best manage them in the parenting plans. How parenting plans can be assessed in terms of meeting a child's developmental needs, as that's a concern that I think a lot of judicial officers have, that the developmental needs of the child aren't really being considered in terms of what the parents are doing. Also, how we can do things that will reduce the opportunity for confusion between parents as they move forward in implementing the parenting plan, and also reduce the opportunity for conflict. The other thing is, if people can, people don't want to come to the courthouse the first time, they certainly don't want to be here the second time. So if we can create parenting plans, avoid the need to return for court modifications, that's going to be very helpful as well. The last thing is to avoid potential contempt motions. There are things that people do that are, in my mind, contempt generators that create an opportunity for filing of contempt. And last but most important is to make the judicial role easier. Not that we should be kissing our sister, as this picture indicates, but I will tell you, we commissioners love the facilitators. You make our job so much easier. All right, so the idea was to go through the parenting plan specifically and walk through each section of the parenting plans, so that way we can talk about each section in context, and then I have some wrap up things at the end that are kind of catch-all issues. But obviously, I think you all know that we have mandatory forms. A lot of times people try and essentially get around doing a modification of a parenting plan by issuing a new temporary order, or putting things in findings where else, for some people might put the chemical dependency evaluation needs to be done there. No, all that language needs to go in the parenting plan. And the reason for that is because when we get the contempt motion, the contempt statute says that the commissioners and judges have the ability to issue contempt orders on violations of parenting plans and child support orders. We don't have technically the ability to hold people in contempt for violations of the temporary family law order. So make sure that the family law stuff is in the parenting law, or excuse me, the parenting plan stuff is in the parenting plan itself. Obviously, in the words of the Mandalorian, this is the way. All right, so section 1, pretty basic. You're going to identify whether it's a proposed order or a actual in-court order. A lot of times, I think we're particularly on temporary orders, we're printing the proposed order, we're scratching out the word proposed, we're checking the box for a court order. Many of you probably to what's it called? FamilySoft. FamilySoft has this program that allows you to condense a parenting plan. The Word format also allows you to click on a little arrow that gets rid of unused sections. The dilemma with that is if your client hypothetically says, dad should not have any custody of the child, should have no visitation, no holidays. If the judge wants to order something else and you've deleted the holiday section, then it means the judicial officer has to recreate that. So on temporary parenting plans, I encourage you not to condense or shrink those parenting plans and eliminate the unnecessary things. Just don't check the boxes. There is a difference, however, between temporary and final parenting plans. Final parenting plans, I actually encourage you, particularly if it's agreed, or if you're memorializing the decision of a judicial officer, condensing the parenting plan and removing the paragraphs that are relevant is probably helpful, particularly for self-represented parties, because they don't have to look at language that's not particularly helpful to them or relevant to their I am personally not a fan of initials of the children. A lot of people, if they've got a criminal background, often will put the initials of the children, JHL, age 7. It does make it a little difficult for the court. We get into gendering children. If their initials are JHL, we don't know whether or not J is a male or female. When we have those conversations with the customers in the courtroom, it's just easier if we know the names of the children. I also think it kind of makes the court less, makes it more impersonal if we can talk about little Johnny as opposed to your minor child. I think it helps us connect with our customers a little bit better. So I'm not a fan of initials. Do put the ages of the child. A lot of people leave the ages out for some reason. The ages are important because developmentally, a parenting plan that may be appropriate for a 14-year-old would not be appropriate for a 2-year-old. They need the last name, that's kind of irrelevant at some point. All right, so here's where we get into the heart of parenting plan cases. Section 3A is talking about limitations that a court may find in terms of a parent's past behavior that would restrict their ability to have time with the child. And oftentimes you'll hear lawyers talking about 191 factors. That comes from 2609-191, the actual statute. And this permanent parenting plan shall not require mutual decision-making or designation of a dispute resolution process other than court action if it's found that a parent has engaged in any of the following conduct. So the first thing to know about this portion of the statute is that this portion of the statute only applies to final or permanent parenting plans. They don't actually apply to temporary orders. But if there has been a finding of child abuse or sexual assault or violence, then we can't order joint decision making and we can't require parties to do out-of-court mediation. Willful abandonment, substantial refusal to perform functions, parenting functions, physical, sexual, or pattern of emotional abuse of a child, or history of acts of domestic violence. And so that's what this 3A is talking about, these types of findings, that we can't have joint decision making and we can't have out of court mediation. However, in section 3A, I think a lot of people are like, well, I have all these concerns about this, that, or the other. And I think on proposed parenting plans, if these are the arguments that your client, or excuse me, your customer is arguing, mark the boxes. The court can always draw a line through them, use whiteout, whatever it is to fix it if the court's unable to make that same finding. But we get, and I won't say this in facilitator cases, but we get it in a lot where people want us to make all kinds of horrible findings about somebody, but there's no evidence of it in the file. It's not even alleged. So make sure that the findings are supported by the evidence. And it is a shall. We do not have the ability to order joint decision making or mediation when there is these types of findings. If a final domestic violence protection order has been entered, or there's a criminal conviction involving the parties, there's a high probability the court is going to make these findings. It's pretty rare that the court wouldn't make these findings if there was either a domestic violence protection order or a criminal conviction. And make sure that the criminal conviction is one involving the parties. Just because one person assaulted their, spouses number 1, 2, and 3 doesn't necessarily mean that there is a finding that there was an assault on spouse numbers 5, 6, or 7. Particularly on temporary orders, you can also mark reserved. We're going to have a guardian ad litem or a custody investigation parenting evaluator come in. We're going to, there's a pending criminal case, that type of thing. You can reserve it and reserve it for trial or settlement. All right, section 3B. Now this is optional. There's a presumption and it creates a may limit. So if the court finds any of these findings, then it may limit the ability of a parent to have contact with the child. And it's the court has the ability to enter a reserve finding, particularly on the commissioner court for temporary orders, reserve it for trial if it's unclear at this point. And this is neglect, emotional or physical problems, substance abuse. And the other thing is, it's important to know that these allegations have to be ones that affect the child. And so a lot of times there will be an allegation that, Bill is an alcoholic, but if Bill is an alcoholic and he's got alternate weekend visitation and he only gets drunk on the weekends, he doesn't have the kids, it's probably not affecting the children, right? On the other hand, if they get drunk 24/7 and the child's being left, unfed and unattended, then it is a substance abuse problem that does affect the child. Section 4, limitations on the parent. So if we found a 191 restriction under 3B, then we do have limitations in terms of, again, decision making and mediation. But 3A. In 3B, if we found limitations, it doesn't mean that the limited parent doesn't get time with the child. What it means is that we're going to have provisions that address those concerns in terms of the contact between the child and the parent. So, for example, if dad has a chemical dependency issue, but he's in recovery, we might say that dad has the time scheduled in section 8 below, so long as he maintains going to 3 AA meetings a week and provides proof of that to the court. And so that's his limitation. He just has to sign off saying that he got his receipts going to the AA meetings. Other times we might have supervised contact. We might be ordering evaluations or treatment. Do make sure that these evaluations are ones that are related to the actual findings. A lot of times people will want a mental health evaluation, but there was no mental health finding in section 3B. If we're ordering supervised visitation, I know this creates a opportunity for conflict, it creates an opportunity for contempt, and it creates an opportunity for delay in the limited parent seeing the child. And people have to come back to court for second or third or fourth hearings, and that ties up our calendars. A lot of times, the visitations will be supervised by a professional agency on Saturdays from 1 to 2, right? That's fine. The dilemma is, unless somebody's called the agency to make sure that they have availability at 1 to 2 on Saturdays, then it's not going to happen. And so then you have one parent saying, I get my time at 1 to 2, the other parent saying, well, the facilitators or the supervisor's not available from 1 to 2, therefore you don't get your visitation. And so I always include language that says, or at times arranged by the supervisor. So if the supervisor is not available from 1 to 2, but is available from 3 to 4, then you can do it at 3 to 4 because it's been arranged at that time by the supervisor. Understand the distinction between a professional supervisor and a lay supervisor. Uncle Bill and Aunt Sue and Grandma and the neighbor, may be appropriate supervisors. There is an oath of supervisor that can be signed by lay supervisors, and that can oftentimes reduce the concerns that your client or customer will have about the specific supervisor. Particularly on temporary orders, people may not know who proposed supervisors are, either a professional supervisor or a lay supervisor. Some of the language that we include is that the parent A will nominate 3 potential lay supervisors, and then parent B will select one of the 3, or vice versa. So that way there's a process, so that way they don't have to come back to court to get that resolved. Also understand that sometimes these provisions have unrealistic expectations about what a supervisor can do. Supervisor agencies are charging $75, $100, $125 an hour. I've seen even more expensive than that. My guess is throughout the state, the costs vary, but you get 2 minimum wage parents, and we're talking about supervised visitation, and somebody says, okay, yeah, dad can have supervised visitation from Friday at 6 to Sunday at 6. Well, $100 an hour for 48 hours, that's $5,000 a week for visitation for somebody who's making $2,100 a month. Doesn't make any sense. So also understand not just cost for professional supervisors, but for lay supervisors. Grandma may not want to spend all day Saturday at the zoo with a couple of 4-year-olds. That sounds like a nightmare to me. I'm sure Grandma doesn't want to be on the hook for supervised visitation for that time period. I'd also encourage folks to have as many potential supervisors as possible. The supervisors have a tendency, particularly on temporary orders, to lose interest in providing the services that they've provided. Just kind of a be aware. A lot of times people are asking for the parent who there is not a 191 finding factor may be over or hyper controlling, and they may want all kinds of limitations because of their own mental health psychosis or their own power and control issues, and that can be an issue. Additionally, one of the things that just kind of irritates me is when people say, oh, no contact with the new significant other. This is generally a husband or boyfriend trying to keep the ex-girlfriend or ex-wife from getting a new boyfriend, as opposed to any specific concerns about the child and the child's ability to understand the new relationship. Developmentally, there are problems with a child being introduced to new partners too quickly, or too many new partners in succession, and so there is some developmental basis for it, but also beware that it has to be balanced against whether or not the requesting party is really seeking to control the other party's new relationship. The no exposure to extended family. I don't want grandma to be the supervisor, or I don't want, if there's going to be visitation, grandma can't be there. Well, then the court asks, well, why don't you want grandma to be there? Well, grandma likes him and has always hated me, and I'm afraid that she's going to badmouth me to children. Well, that's not a basis to keep somebody's grandchild from somebody, from the grandmother. But if grandpa is a convicted sex offender, then that is something that's reasonable. Then there's all that gray area in between. make sure that the treatment and evaluations are related to the limiting findings in section 3. I think I already talked about this, but it's really important that if we're going to order treatment or evaluations, that there be some sort of findings or evaluations are relevant. A lot of people are just like, my wife is crazy. I want to have her have a mental health assessment. Well, that's not anything rational, right? If it's my wife was suicidal ideation, she was talking about ghosts and she swears the dog is out to kill her, whatever it is, then maybe there is a basis for mental health assessment, but we need to know that information. Be conscious of who's going to pay for the evaluation. People are very, very liberal with other people's money. I'll spend other people's money all day long. But particularly for the folks that you have coming in, a mental health assessment is like, particularly if there's not health insurance for it, $5,000 to $10,000. A domestic violence assessment, you're looking, depending on where you are, $1,500. Some people don't have the money to do this. And so make sure that what I try and tell people is, if I'm ordering these things, I want to make sure that we're getting a return on the investment for the children. Now, sometimes they're necessary, and the parties are going to have to come up with that money, but make sure that it's there. One of the common things that I have is when people are asking for evaluations or treatment, there's a cost to that, and we don't get people who file financial declarations, or in King County, it's local family law rule 10 that says you have to file financial disclosure forms. And so if your customer is saying that they want somebody to complete evaluations, you really need to think, well, there's a cost to these evaluations. Who's going to pay for them? And if asking the court to order somebody to pay for them, then make sure that they're filing their financial documents consistent with at least a financial declaration, probably 2 years worth of tax returns with W-2s and pay stubs. If you are ordering any reports, or if you're asking the court to order any reports, I've seen parenting plans come back where the report was ordered, but then nothing happened with the report. So what are we going to do with the report? Ideally, what will happen is that the court that the evaluated party will file with the court within 72 hours or 3 days or a week or 14 days, whatever it is, of a receipt of the report, a copy of the report into the court file, and copy the other party, or just mail it to the other party if you don't want to put it in the court file, whatever the order may be. But we have to do something with the report, particularly to make sure that the other party gets a copy of it. If we're talking about phases, oftentimes people in the limitation section will talk about phases. Make sure that there's clear benchmarks. Phase 1 of visitation with little Johnny will be this, phase 2 will be this, phase 3, etc. But we want to make sure that the benchmarks for going from phase 1 to phase 2 or phase 2 to phase 3 are clear and easy for people to identify. So, for example, a time, 3 months or 6 weeks or however long is really a good way of doing it. But say it's, 3 months from the issuance of this order, or 3 months after the first visitation, or July 16th, if you can be, so it reduces the opportunity for confusion or conflict, that would be helpful. Oftentimes we're ordering people to go to NA or AA meetings or domestic violence batterers intervention treatment programs. And so we can say after they've completed 12 classes, or after they've gone to 12 AA meetings, or had 5 therapy sessions, or whatever it is. And then, oftentimes in contested parenting plans, there's a trust issue. So, what's going to be the evidence of completion of these classes, or, which, so we'll say has attended 12 DV classes and has submitted a letter from the DV treatment provider indicating 12 attendance of 12 classes, something like that. To make it very clear. 4 negative UAs, right? Many of you, if you've ever done any chemical dependency stuff, you know that there's negative UAs, there's positive UAs, and then there's all these UAs that are high creatinine levels or dilute. If you can include whether or not a dilute or high creatinine UA is considered a positive UA in Thurston County. When I was there, our chemical dependency orders included language that said a positive or dilute UA was considered a high creatinine or dilute UA was considered a positive UA. That eliminated anybody's ability to dispute whether or not it was a positive UA or not. It also reduced cheating. So section 4, what if the parent does not?
Quick question,
Oh,
Commissioner.
sure.
Sorry, going back to the previous slide. This is Kaylee. Has the bench talked about writing up almost like an attachment to the parenting plan that could be used as options for evaluations and treatments that the facilitators could use to then just mark boxes that are actually, or even that pro se's could use, that are actually in line with what they're wanting done, instead of it being some unreasonable request?
So the bench is an interesting concept. We are not the Jedi Council that meets once a month and we agree on everything, and we vote on it and hope that Master Yoda gives us proper instruction. I would say that in Thurston County, when it was Commissioner Thomas and I, now Judge Thomas and I, we sat down, we agreed on everything. We talked to the judges, we had forms, we had attachments, we had chemical dependency orders. I mean, it was nice because there was 2 of us. There are 9 or 10 in Spokane County. They're all wonderful and brilliant. There's 6 of us that do, 7 of us, 8 of us in King County that do them. We're slowly getting there, but in terms of statewide, no. What I would encourage you to do is talk to your commissioners about proposed languages or a proposed uniform language or proposed forms that they can use. We've got some standardized forms that we do for chemical dependency here in King County. I will confess, I wouldn't know where it is and I don't use it because I forgot about it until you mentioned it. But it was kind of common practice in Thurston County. So talk to your individual bench about that. And if you have ideas, just email me and I'll be happy to see if I can come up with something or maybe know of a resource. The commissioner listserv is great. We send out emails to each other, every once in a while saying, hey, does everybody have a proposed order that does X, Y, or Z? And if we can have those kind of statewide, that is helpful. The difference, one of the dilemmas is not all the resources are available county to county. What is available in Okanagan County and what's available in Pierce County may be 2 different things. And so I think statewide forms are going to be difficult, but bench to bench, I think that's a great idea.
Thank you. And I'm happy to help too, if need be. Thank you.
Great. And so then in section 4, what if a parent does not follow the evaluation or treatment requirements above, then what happens? Don't set parties up for potential contempt. There's always this, then the mother shall have the discretion to suspend visitation, or the father shall be able to do this, or whatever it is. When you have something that requires somebody to make a decision, that's an opportunity for contempt. So I always put return to court because there is an emergency process. If somebody has a hot UA, you can come into court that day or the next day and get an emergency order suspending the other person's visitation. It could also be something as simple as suspend time, right? If they fail a UA, their time is suspended pending a return to the court. Just make it automatic. So that way there's a clear benchmark. And if it's met, then there are consequences there too. It could also limit time, right? Instead of the visitations, if dad has a hot UA, he's not going to have Saturday, Sunday visits. He'll only have his Monday, Thursday visits at that point. Or you could impose a supervisor. If mom has a hot UA, then we shall return to mom having supervised visitation with a professional lay supervisor. You could also theoretically say that if there's a hot UA or dad doesn't do his mental health assessment, then the overnight visitations would be suspended and the visitations will be daytime only from 10 a.m. to 7 p.m. or something like that, right? All right. Decision making, as I indicated in section 3A, if there is a domestic violence finding or one of those other findings, you are limited to doing sole decision making in one parent, probably the parent who hasn't committed the egregious acts. But the statute doesn't actually say that, but I think that's a logical conclusion. There's generally a default to joint decision making for parties. The dilemma is if people could agree, they'd probably remain married. So that's not always possible. If there are 191 findings under 191, the first part and 3A, then you can't do joint decision making. Long distance parenting plans disfavor joint decision making. It's really hard for it's kind of weird to have, mom who's in Tampa Bay, Florida, making decisions about whether little Johnny should attend soccer in Spokane. It's a little odd. And so it's kind of disfavored. On the other hand, parties get along and they can make those things work, and people are responsive to emails and phone messages and whatnot, then they can continue to have joint decision making. You can also divide the issues. For example, let's say religion is particularly important to one parent and it's not important to another. They could have joint decision making on everything, but then mom gets to decide the religion of the child because the parties agreed that the child would be raised, Jewish. You can also predetermine issues, and I actually think this is favorable in many cases. Instead of saying the parties shall have joint decision making on this, that, and the other, the things that come up for small children oftentimes is if any of you've ever had a baby, they get the tubes in their ears to drain the water. For 90% of all Americans, the issue comes up about whether or not you're going to have braces or dental work. And oftentimes people, braces aren't an issue in your mind when you're dealing with a 3-year-old who hasn't lost any teeth. They are huge when they're 15 and you're looking at $30,000 worth of uncovered orthodontia. And so what you can do is say that the parents agree that they'll have joint decision making. However, they've already resolved these issues. Little Johnny will have any recommended orthodontic treatment. Private school is another one, or where the child is going to go to school, particularly if you've got magnet schools like a Spanish immersion program, or a parochial school or Seattle Prep or something like that. Then agreeing to private school and education up front, so that way they have joint decision making on private school or on school, like the child in Head Start, those or Running Start, those types of programs. If you can resolve those issues earlier, then it means people don't return to court. The other one that comes up is driver's license. Generally the non-custodial parent wants the child to have the driver's license, and the custodial parent says, no, little Susie can't have a driver's license until she passes, I don't know, one class. And so what the driver's license issue is happening is the non-custodial parent is really trying to get little Susie to move in with dad. So if you can resolve driver's licenses when their child is 3, that the child shall, assuming they've got a 3.0 GPA or whatever restriction the parents want to put on it. If you resolve it at 3, then they don't have to come back to court at 16. Section 6 is dispute resolution. Again, if there's a 191 finding, and even though the statute talks about 191 findings in terms of 3A and not 3B, I would generally probably waive dispute resolution if there's other things like child abuse, neglect, absence of the father, or absence of a parent. And that's because those things can be endemic of domestic violence or the potential for domestic violence. And so if we can just get people to go to court when there's those issues, that's probably a best option. The statute does provide for arbitration or counseling. I will tell you, arbitration means that the parties are stuck with the order or the decision, kind of. All parenting plans are subject to judicial review. Even if there's arbitration, you could have to come back to court. And people don't really understand that. And they're like, well, the arbitrator said this, and I can't believe why we're back in court. Well, if it's mediation, I think it's a little easier for people to understand. Counseling can be problematic. Oftentimes, one, the counselors aren't qualified to do essentially a parenting plan mediation. Second, identifying the counselor can be problematic. If the counselor was mom's therapist, and dad hasn't seen this therapist for 2 years or whatever since they separated, and mom wants to use this therapist, now dad says, oh, that therapist is going to be aligned with mom. So that can be problematic. The other thing is, when you're picking the mediator or the person who's going to help people resolve, make sure that they're actually somebody who can and will do it. Oftentimes people will put, Pastor Sue or Pastor Bill in there, and Pastor Bill will be like, you know what, I'm here to help you with Jesus. I'm not here to help you with your kids, right? I don't do this. And so now what we have is a listed dispute mediator who won't do it. And now what do? You got to come back to court. have a check and say, you've suggested that Pastor Bill will be the mediator. That's fine, but have you checked and see whether or not Pastor Bill is willing to do this? And so you call Pastor Bill and say, "Hey, Pastor Bill, I'm filling out this paperwork. Do you do this type of thing?" And Pastor Bill will tell you yes or no. If Pastor Bill says yes, then put his name in. Right. I would also encourage you to name more than one. Unfortunately, people die, people retire, people get tired of cases. And so if you can name more than one, that's great. And I would name them in order. So the party shall use mediators, Brown, Smith, Jones, the first of whoever's first available. If sometimes people come in and they're filling out the paperwork with you, they've never thought about anything, they're just sitting there looking at this 12-15 page form, and they're like, well, I haven't thought about anybody. Well, you don't want to leave it blank, because you do want people to go to mediation if possible and stay out of court, because it's the best way of resolving things. But what you do is say the person who's seeking mediation shall nominate 3 available mediators, and the other shall select one within X number of days of receiving the name. So now, instead of having the names because you don't know who they are, because you haven't thought about it with your customer, or your customer hasn't thought about it or done any research, you've created a process that makes it so that way they can select a mediator without coming back to court. It reduces the need for another hearing. So custodian, this is important language in Washington State because it creates a presumption for relocation. The custodial parent is theoretically allowed to move with the child over the objection of the other party. And so oftentimes people dispute the custodian who should be the custodian, but it's largely affects the issue of relocation under Washington statute. It does also create a presumption for taxes, and people get into who's going to claim the child for federal income tax purposes. And the important thing to understand is the federal IRS code says that the parent who has the child more than the other shall be entitled to claim the child unless there's a court order otherwise allocating, or there's agreement of the parties. And so a lot of times we'll get people who only think about the first part. Oh, I get to claim the child because I'm the custodian. Well, maybe. You get to claim the child if you're the custodian and there's no other provisions anywhere else saying anything otherwise. And so it does create a presumption on the taxes where this will end up being resolved in the child support order. The child support order theoretically should allocate the tax deductions for the child, or who gets to claim the child for tax purposes. One of the ways that this comes up that can be problematic is if there's not a child support order, but an administrative order. The administrative orders out of the department do not allocate taxes. And so you may have a case where in the parenting plan, you need to allocate the tax responsibility, or who claims the taxes, because there's an administrative child support order instead of a court child support order. This came into play a lot because people were getting COVID relief funds for their kids. And there was this dispute over who got the funds. And generally, I think the way at least the King County commissioners were approaching it was that the COVID relief funds went to the custodial parent. The other thing is people don't realize that the parties can be the joint custodians, essentially doing away with the presumption, particularly on 50-50 custody plans, or plans that are kind of within the ballpark of 50-50 custody. There are some tips. If you've got multiple children, sometimes you can be custodian of parent A gets little Johnny and parent B gets Lily. That creates a situation where you get a preference to move, but only with one of them. Which means both parties are essentially handcuffed to whatever town they're in. And that can be a way of, kind of assuring that the parties don't move. Now, is that problematic? It may be in some cases, and that's something that each customer is going to have to assess on their own, or maybe talk to an attorney about. Limited schedule. Make sure that you put the limiting schedule in section 4. Please do not put it in section 8 if it's a limited schedule. But again,
Quick question about the custodian. So they can write in there both parents.
Yeah, absolutely.
Okay.
Jonathan and Steve shall be jointly custodians for purposes of all state and federal statutes. What that means is they've essentially gutted the statute. A lot of times, and we'll see this in the relocation section, people want it to delete sections of the relocation statute. That's actually not permissible in the statute. The statute requires that language be in the order, so you can't change the relocation language in the order. So what you really want to do is change who the custodian is, and if you want to gut the relocation portion of the statute, just make parties joint custodians. That's the legal way of getting around the problem that I'm identifying.
Is it true? This is Sharon. Is it true that if people select joint custodians, it creates absolute havoc with the division of child support, as far as like if somebody goes on TANF and then where a DBA, now you've got a full-on transfer payment, and we're told that when people say joint custodians, it causes all kinds of messes administratively.
Well, it causes administrative messes because people are overthinking the problem. You know, a 50-50. So the child support formula, if there's a deviation based on residential credit, is based on the number of it's based on the parenting schedule custodian is. And so worrying about the custodian, I think, is the department contemplating things that aren't particularly relevant. They want it easy. They just want to look at the custodian. They don't want to have to do the math and figure out who has more overnights than the other. But I don't think it is as big a problem as the department may be saying. That being said, the department is regional, and so maybe, you know, regional offices have bigger problems than other regional offices. On a 50-50 custody schedule, the custodian shouldn't make any difference. Now, I do understand that there are situations where you've got an unemployed parent, or a parent who's on, you know, TANF or disability. The department theoretically is weighing in on those cases before the child support order is issued, and the child support order theoretically is being issued at the same time as the parenting plan. And so I would encourage the parties at that point, if it's a 50-50 schedule, it's not that big of an issue. Where it is going to be an issue is where you have, let's say, a 60-40, but you're saying the custodial parent is the 40% parent. That's going to be problematic because the custodian doesn't really match what the parenting plan is talking about. But there may be reasons that the minority parent, the parent with less parenting time, may be the custodial parent for tax purposes. You know, so there's a lot of variables there, but I don't think it's as big a problem as the department thinks it is.
Thank you.
I ask a question, Your Honor?
Sure.
Okay, what I'm hearing Sharon say, though, is that if one of those parties goes in to apply for food stamps and they're not getting a child support because they're doing a residential split, they won't qualify for food stamps if they're not, if they're I don't think DSHS recognizes co-custodians.
Well,
Yeah,
but
that's what I say is
Right.
we've seen nothing but problems when people put two names down under custodial.
Yeah.
It causes problems on every level. Sometimes
Yeah.
an unintended full transfer payment goes against the party who least expected it, and also then nobody's eligible for food assistance, and just various things. So I just was wondering what your experience was with that.
Yeah, but that's going to be something that really is based on the amount of time that the parties have with the child. So if they're joint custodians because they have a 50-50 parenting plan, then you know, that does create a problem for TANF and public assistance, but they still have a 50-50 parenting plan. At some point, somebody needs to probably file a petition to modify it, because if somebody can't feed their children, those children probably need to be with the parent who can feed them and will feed them. And so one, I think the department's making it more complex than it needs to be, but the other thing is maybe we're being unfocused and we're looking at this one provision and going, well, but if mom is living in a car, or excuse me, living in a van down by the river and can't feed her children, somebody needs to step in and do something else with the custody schedule as well. So there probably needs to be a petition to modify. All right. Section 8, in terms of, and I apologize, we're moving a little slow and there's a lot to do here, but generally we talk about children under school age. We're talking about having a primary connection, and this is a general concept. The specifics of each individual family will be different, and things may be appropriate for one family that are not appropriate for another family. But when generally we talk about if we're going to have overnights for younger children under school age, they're probably able to be away from their primary custodian one night for every year that they are. So theoretically, a 2-year-old could do 2 days on, 2 days off, 2 days on, 2 days off. That's not to say that a 2-year-old can only have 2 days a week away from the parent, but they can be away from the parent for 2 days at a time without developmental problems occurring. There's a lot of every other weekend and Wednesday kind of language, but also think about transportation issues to school, right? If dad lives in Tacoma and mom lives in Bellingham, return on Monday mornings doesn't make any sense because that's going to be, a 3-hour drive, 4-hour drive to get to school on Monday morning. Routine is very important, particularly for children who have special needs. If parents can have the same routines, then it's less impact about the transitions. Some sample language, week on, week off, every other week schedules could be appropriate. Alternate Fridays, I put after school or 3 o'clock to Sundays at 6, Wednesdays after school to 7:30. Those are the type of languages that we're generally talking about for children who are under school age. For school age children, generally it's one night for every year of age is developmentally appropriate. Again, you need frequent contact with smaller children, but there's no hard rules and may different to judge. Some sample languages, again, for particularly smaller children might be a Monday, Wednesday, Thursday, kind of what I call the dinner dates. Please put 12 noon. Many people will put 12 AM because they think noon is AM, and then we get the contempt order and it says, at 11:49 I was sitting in the driveway and she wouldn't give me the child and now I want her held in contempt, but the order says 12 AM, which is midnight, and so the exchanges according to the order were supposed to happen at midnight even though everybody thought it was 12 noon. So use noon and use midnight if possible. Some other sample language that's possibilities are, in my mind, is Thursday because Tuesday is T. If there's domestic violence or power and control issues, abuse, you want to reduce the frequency of exchanges. So even though a child should have frequent short contact at the non-custodial parent, the smaller they are, you may want to limit that because it creates opportunity for conflict between the parents. For summer schedules, generally 1 week per year the child is the child's age is developmentally appropriate. So for example, a 10-year-old child could have 10 weeks away from the other parent, the primary caregiver. Marking it's the same as school year is completely appropriate. Moving to a week on, week off schedule in the summer may be appropriate because then people can take those week-long vacations. If you're going to do week on, week off, are you going to talk about a midweek dinner date like on Wednesdays or something like that? Phase schedules are also a possibility. As the child gets older, the child in year 1 will have 4 weeks with dad. In year 2 will have 5 weeks, 6 weeks, and moving forward to expand. Also create a situation where if people have provisions, party will get 2 weeks of extended summer visitation to take the child to Disneyland or whatever. Put in a process for how that's going to be established. Generally, mom picks in 1 year, dad picks first the second year. I like April 15th. It gives parties enough time to plan for their summer. The other parent, May 15th, and April 15th is a date that most of us know because it's the day where our paychecks go to Washington, D.C. Make sure that you clarify whether or not the dates for the extended visitations have the ability to conflict with any of the holiday time in section 10. In section 10, try and avoid conflicting provisions. Keep it as simple as possible. Most Monday holidays fall on a Monday or Friday, so I generally just mark the box that says with the parent who has a child for the attached weekend. Generally, each parent will get their own birthday, but think of complications. What if it's a school day? What if it's if you're your father's Thomas Jefferson and you're born on the 4th of July, right? Non-specified holidays, the parenting plan holiday schedule is very Western Christian oriented. Think about other holidays, Ramadan, Yom Kippur, whatever it is. Also remember that the Chinese New Year may conflict with President's Day. It's generally in late January, early to mid-February. And in Vietnam, for example, the Chinese New Year is a 2-week process. So make sure that you understand that the Chinese New Year, define what the Chinese or Vietnamese New Year means. It may not be a specific day, it may be a 2-week event. Verify the children's breaks. Some, for example, in King County, some schools have spring break, some schools have midwinter break, and some schools have both. Somebody mentioned the siblings holidays that are siblings birthdays in the chat box. That's a good one. Even odd split, mom gets mid-year winter break in even years, dad gets in odd years, that kind of a thing. One thing to remember is that President's Day often falls in the midwinter break. So if it's midwinter break, but dad gets President's Day, you've got a conflicting order. Easter also may fall during the spring break. So again, make sure that those don't conflict. Mother's Day is going to be with mom. Father's Day is going to be with dad. I actually just signed off on a parenting plan the other day where Mother's Day is always with the dad until dad's mom dies, which seems strange to me, but parties agreed to it. That's fine with me. This comes up. It's okay to have same-sex parents and allocate Mother's Day to mom A in year 1 and Mother's Day to mom B in years 2, but then give mom A Father's Day, right? So that they can do something, even though they're not a father, right? So they get a special day as well. If it conflicts with the weekend schedule, what do you do, right? If Father's Day is on Mother's weekend, then you need to contemplate whether it start on Saturday or start on Sunday, how you're going to do that. The 4th of July is a nightmare of a holiday because it's never on the same date. It's rarely on a Monday or Friday. It often conflicts with the weekend schedule. What I always do, unless the parties do something else, is with the parent who would otherwise have the day under the schedule in Section 8, I essentially make the holiday go away. For the winter, Thanksgiving, winter break, Christmas Eve, Christmas Day, New Year's Eve, New Year's Day, I think you need to think of this as a package. Whoever gets Thanksgiving does not get Christmas, but then whoever doesn't get Christmas probably gets Christmas Eve. Odd and even, this is pretty standard, but then also define what Thanksgiving is. Generally, I do from after school and the day before Thanksgiving, to the Sunday at 6 p.m. before the resumption of school. The same with the Christmas holiday, or break it up December 26th to the Sunday before the start of school in January. Generally, you split up Christmas Eve and Christmas Day. My parents had exchanges at 10 a.m. on Saturday, on Christmas morning. What did that mean? Christmas morning was spent in a cab. That's a bad plan in my mind, but apparently Judge Brown thought it was a great idea for me to spend Christmas in a cab going between my parents' house. Also, don't forget the Russian or Eastern Orthodox Christmas is January 7th. Eastern, for those of you who have a number of Ethiopian or Somali folks, if they're Somali or Ethiopian Orthodox, it is January 7th is that holiday as well. All other 3-day weekends, the big one is Indigenous Peoples Day is not it's generally if it's on a Monday or Friday. If you have a King County employee or a state employee, let me back up. If you're a state or federal employee, Indigenous Peoples Day does not exist. If the other spouse is a Seattle employee or a King County employee, they get Indigenous. So to one parent, it's a 3-day weekend, and to another, it's not. So don't say all other 3-day weekends, list Indigenous Peoples Day as a 3-day holiday, or specify them. So that way there's no opportunity for disagreement. Conflicts and scheduling. This is a trap. This is not the language you're looking for. What I really encourage you to do is just check the box that says name holiday should be followed before the school breaks. Everything else is very confusing. Transportation arrangements. Again, this is a contempt trap. Think about ways of reducing opportunity for conflict. Third parties who do exchanges will tire and quit. Public exchanges can be awkward for a child. Nobody is at a police station. There are never police officers at a police station. They're always out in the field. That's all, the only time they're there is when they're filling out paperwork. You can't change the relocation statute. And also understand that you may need to contemplate that one parent is going to move, right? You're going to live together. So there may be a relocation that's contemplated. Put that in section 14. So that way we know it's contemplated and that it doesn't trigger section 13 for relocation. Section 14 is a contempt generator. This is where all that feel-good language goes in about thou shalt not disparage the other, that kind of stuff. If people want to put it in, that's fine. But generally, it's just a contempt generator. It is the Death Star in terms of parenting plans issues. Some other problematic parenting schedules, you think you're going to kiss the princess, but it turns out she's your sister, right? Year on, year off are probably not going to be approved. Month on, month off are probably not going to be approved. Think about, talk to the customer and say, is the child going to switch schools every year? Stability is a key primary factor in parenting plans. And if so, you're approving a parenting plan that's going to have a child change schools every month or every year, that's probably not stability for the child. Think about the logistics of going into school every morning. I'm going to skip the video, but long distance parenting plans, this is a video of doing the Kessel Run in 12 parsecs. But if you're in two different states or two, east side, west side of Washington, you might have a school year parent, you might have a summer and holiday parent. Have the parties considered transportation costs? If there's a administrative order, it probably hasn't. If you're doing it, transportation costs, it probably needs to be allocated in the child support order. People don't understand how unaccompanied minor works. This is the Alaska Airlines rule. It is not uniform throughout. So make sure that you're understanding what airline the child probably will be flying on. For most of us, it's Alaska Airlines, but there's an unaccompanied minor you can't fly without a parent under 5. Between 5 and 13, you can fly, and a flight attendant will take you to and from the gate. There's a cost to that. That fee is paid at check-in. So create a situation where how that is going to be paid for. If the parenting plan, or the child says that the dad will pay for transportation costs, dad makes the plane arrangements, mom takes the child to SeaTac, mom says, oh, there's this $50 unaccompanied minor fee, you didn't pay it, the kid's not getting on the plane. That's a problem. So, how is the unaccompanied minor fee going to be covered? Contemplate international travel. We've got folks in the military station in Korea and Japan. What's going to happen with the passport if these are issues? Special considerations, and I know we're coming up with shorter time because I think we're going till 12 or till 1. Unhoused parents, what are you going to do? So you might do a phase that says, upon securing housing, this will be the schedule. Until securing housing, this will be the schedule. At child's discretion is really disfavored unless the child's kind of 15 to 16 and has a car, that type of thing. You have cases where people don't have a lot of money. Dad's living in Alabama. The visitation really needs to take place in Washington because the child is young. Dad needs to be able, you might not have a specified schedule. You might say Washington for up to 72 hours upon 30 days notice, right? Assuming dad will get the child to all soccer games or whatever. Intersection with protection orders. The important thing to know is the protection orders with a child last for 1 year. We can't make them last longer. There's some quirks in the DV statute that are new that kind of fix this problem, but as a general proposition, they only last a year. The idea is it gives people time to go and get a permanent parenting plan or modify the current parenting plan after the issuance of a domestic violence protection order. Domestic violence protection orders can be renewed, but I would encourage judicial officers, if you're issuing protection orders, ideally they're putting in subject to subsequent orders in the parenting plan action. That way the parenting plan stuff can be moved from the domestic violence docket into the parenting plan. I think all the commissioners are probably doing this. I think it's a general practice. So as a wrap up, I would say don't be afraid to chat with your commissioners. I am but one of, I don't know, 6 million or whatever here in Washington State. That I look anything like Mark Hamill in his 20s with his shirt off, but you all are the Mark Hamills, and you carry us. We may be the old gray-haired, big-eared people who get to kind of mentor you or whatnot, but you should reach out to us if there's things that we can do to help you. If you're not comfortable talking to your commissioner for any reason, email me. I can talk to your commissioner for you, or find somebody who can. We do meet each other a couple of times a year, and so we develop relationships. But don't be afraid to reach out to us and ask for guidance and mentorship, because I certainly reached out to my facilitators for guidance and mentorship when I was a rookie here in Thurston County. So thank you for all you do, and in your work, may the force be with you. I'm happy to answer questions. I've got time. I know you all probably have other things to get to.
Quick thank you, Commissioner Lack, for your time, and your comedy always has me laughing. So thank you so much, and I'll pause as well to see if there's any questions before ending the presentation.
And my email address is there if you just want to email me. That's fine. I'm happy to talk about this. The other thing is, my guess is I'll be asked to give this presentation in the future. If there's any problems or suggestions that you have, let me know. I fully admit that I know less than I should, and I'm willing to be educated. All right. I think there aren't any other questions, but my understanding is Kaylee has me on the list to help you all with de facto parenting plans next month. So I will discuss that nightmare with you on August 11th.
11th, yes. Thank you.
Bye,
Thank you,
y'all.
Commissioner. And I'm going to go ahead and turn off the recording, and I